Good day, ladies and gentlemen. Joy Stephen from the Pollensis Studios, and here is another Student Herald case law. Vitalis versus Canada. Case law is not meant for people interested to apply for immigration to Canada or permanent residency to Canada, but may be used by those who feel the system may not be fair or to gain an understanding of the recourse available in Canada for a negative decision. Content for this video is sourced from information distributed by Thomson Reuters. Judgment for this case is attached in my blog reportersreport.com as a PDF document. Now, this is an immigration case law and includes topics like selection and admission, humanitarian and compassionate grounds. Applicant was a citizen of Saint Lucia and she had two daughters who resided in Saint Lucia. Applicant arrived in Canada on March of 2010 and was allowed to remain in Canada as a visitor for 6 months. Applicant did not leave Canada at end of authorization period. Applicant had been working as caregiver and employment allowed her to send money to Saint Lucia to support daughters. Applicant applied for permanent residence from within Canada on humanitarian and compassionate grounds. Senior immigration officer refused application. Officer concluded that applicant had not demonstrated that refusal of request would cause unusual and undeserved or disproportionate hardship. Applicant applied for judicial review. Application was dismissed. Officer's findings of fact were all related to sufficiency of evidence that applicant presented rather than credibility. Standard of reasonableness applied to officer's determination of fact. All evidence applicant adduced were duly considered and analyzed by officer. It was incumbent on applicant to provide further corroborative evidence if she wanted officer to conclude that she would not be able to earn living in Saint Lucia. Applicant's failure to provide evidence did not shift burden to officer to verify whether or not applicant would make living based on work experience she had. Officer could draw inferences based on common sense and logic. According to evidence on record, it was open for officer to conclude that applicant was not sole financial supporter of children. There had been no breach of natural justice and outcome reached by officer was within range of acceptable outcomes defensible in respect of facts and law. Vitalis versus Canada. It's dated September the 21st, 2015 from the Federal Court. Thank you.